You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Hi, and welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And, blessings to you as you're listening to yet another episode during our pandemic we have going on here. But praise God again, we still get to connect, and we're so excited to have David here with us again from his home. And we have a special guest today, Professor Adam MacLeod, and I'll let David give him more of a proper introduction a little bit later on. But, one of the things that, if you've been listening to our podcast, we've talked quite extensively about common law and the Ninth Amendment, of course, primarily having to deal with our abortion and marriage legislation and issues that we've been working on for quite some time. And one of the things that Professor MacLeod is really known for is his in-depth understanding of the Constitution, but also common law, especially. And so he's worked with David quite a bit, and so we're excited to hear from him today. And David, you can tell us a little bit more about that.
Sure. I met Adam, I want to say, at least 2 years ago, I guess, Adam. I guess that would be it. But I'd actually went to meet him and a colleague of his that I hope we can have on at some point, Rob McFarland, because they'd written an article relative to an issue here in Tennessee, the Judicial Council's censure of one of our chancellors after the Supreme Court's ruling in Obergefell versus Hodges. And he had taken a position that the Supreme Court had federalized marriage, and therefore he did not have jurisdiction to hear divorce cases anymore. That's what got him in trouble, along with a few other things, but related to the way he said it. But Adam and Rob wrote an article. I read it. I appreciated it. I followed up, went down and met them. And Adam has been really the law professor I never had when I went through law school. And he and Rob both, and so appreciative of his friendship, and which extends beyond goodwill, good cheer, and the law. He's a believer in the Lord Jesus Christ, and it's been wonderful to fellowship with him. Let me give just a little bit of background information about him. We were joking if he had self-taught himself the law, but he's actually a graduate of Notre Dame Law School and was a favorite student of actually a friend of mine who I've known for probably 15 years, Dr. Jerry Bradley, who is a brilliant man and has also been of help. But after law school, he clerked with the Chief Justice in the Massachusetts Court of Appeals. He clerked for a federal district court judge. He's practiced law for a while. He's served as a special deputy attorney general for the state of Alabama, where he is now. He teaches law at Faulkner University there. He's been a visiting fellow at James Madison and also at George Mason University. He's published, he's written. You can find him quite often at the Public Discourse. And more specifically, Adam, some of you may know, came and testified last August of 2019, relative to the common law and the Ninth Amendment as it applies to the issues of what states can and cannot do to protect the rights of their students. So, Adam, with all that being said, unless I got something wrong, welcome to God, Law, and Liberty.
Thanks. It's good to be here.
Well, it is good. And so I want Adam today to help us better understand some things that I've tried to explain, but I think he can explain far better than I. And one of the things that he said in the August testimony that to me was compelling, that I've thought about quite a bit, and I'm just going to tell you what he said, quote it, and then let Adam kind of comment on it. But he began his testimony with this statement: the Ninth Amendment reserves to the people and the states, and the 14th Amendment does not abrogate, the power to specify and secure common law rights, which are those rights that Americans enjoy by virtue of ancient customary law and natural law. So what I appreciated when he made that statement and served as the law professor I never had is that the Ninth Amendment says a couple of things. And so I want you, if you would, Adam, to just tell us what would have led you to say, relative to the Ninth Amendment, that there's a power in the people in the states, and then, two, that power is actually to specify and secure common law rights. Can you give us your thinking behind that statement and what the Ninth Amendment says in those two particular points?
Okay, sure. Well, there's obviously a lot packed into that single sentence, and a number
I'll
of
sit
these,
and wait.
and a number of these concepts, unfortunately, are not well known today, even among lawyers. As you yourself know, you speak to a lot of American lawyers today, and they've essentially been educated by pragmatists. The law is what the courts say it is, and no more and no less. And that's not the understanding of law that prevailed at the time of the ratification of the Ninth Amendment. It's also not the understanding of law that prevailed at the time of the ratification of the 13th, 14th, and 15th Amendments. So the understanding of what law is, which was in place at the time of the American founding, from the Declaration of Independence to the Constitution of 1787-89 to the Bill of Rights, is more or less the same concept as was in place at the time of the ratification of the 14th Amendment, which is why I think it's pretty clear that the Ninth and the 14th Amendment are agreement on this. So what is that law?
And the 14th Amendment, just for those who don't know, was ratified after the Civil War. That's correct.
That's right. That's right. But the basic understandings of law at the time of the American founding and the time of the Civil War were very, very, very similar, both quite different from the understanding we have now 150
today.
Years later.
Right.
So what is that law? Well, if you look at the Ninth Amendment, it says the enumeration in the Constitution of certain rights, so we need to understand what certain rights means, shall not be construed to deny or disparage others retained by the people. And so the first thing we need to notice is the text of the Constitution, and this is true both of the Ninth Amendment and the 14th Amendment and all the other provisions of the Constitution, presuppose that rights pre-exist the Constitution. The Constitution doesn't give us our rights. It doesn't create rights. Our rights do not come from written instruments and positive laws. Our rights pre-exist government. They pre-exist the Constitution. So what the Constitution itself on its face tells us is that there are rights retained by the people, which presupposes that the people had the rights before and they're keeping those rights after ratification of the federal Constitution. So that's the first thing we need to understand, is that the understanding of law at the time, throughout the 18th and 19th centuries, when all of these amendments were ratified, was that law pre-exists government. And our rights, which are founded in that fundamental law that pre-exists government, the whole purpose of having a constitution, the whole purpose of having a government, is to secure those rights. That's the central premise of the Declaration and the Constitution. So then the next question is, what are those rights? Where do we find them? The legal tradition, which everyone took for granted at the time of the ratification of the 9th and 14th Amendments, was known as the common law. This was the law, the ancient traditions and maxims and rights and duties that we inherited at the time of the American founding from Great Britain. So if you look carefully, for example, at the Declaration of Independence, it makes a specific reference to our Constitution. This is 1776, remember. This is a couple decades before the written Constitution drafted by Madison and the other framers. So what could that mean? Our Constitution. What they were referring to was the fundamental unwritten Constitution of British North America, the English Constitution, the common law. And there were certain rights and duties which were understood to be so fundamental in the common law that they were constitutional or fundamental rights, even whether or not they were ever written down or mentioned in any written charters. And
whether or not whether Parliament ever passed a law or not, or a judge ever ruled in a specific case, they had certain rights. In other words, there was a law outside that. Right.
That's right.
Now,
so the existence of these rights.
Do we still apply the common law in any area of law today? Is it completely defunct, or is it still applied in certain instances?
It's applied all the time.
Yeah.
It's applied every time someone enforces a contract against someone else. Where does that obligation, the obligation to honor one's contractual rights comes from natural law, which is part of the common law. And the limits on contractual obligation, the requirement of that there has to be some consideration, there has to be a meeting of the minds. These come from the common law. Every time there's a jury trial, you're exercising a common law right. Where's the right to trial by jury come from? It comes from the common law. So the declaration of these rights in our Constitution refers back to and declares rights which were part of our tradition for centuries and pre-existed the written Constitution by quite a lot.
So when you say, I'm going to just stop you here. But when you say, you said something earlier about legal pragmatist, I guess it was.
Yeah.
What are you meaning by that in the context here of your statements that there was a law that preceded whatever Parliament or the Congress or the state legislature enacted? What did you mean by legal pragmatist there?
So legal pragmatists or legal pragmatism is the view that comes along later in the beginning of the 20th century. So the old idea that we've been describing, which is the idea that everyone took for granted at the time of the ratification of the Constitution and the Civil War amendments, is that the rights and duties of law pre-exist government, pre-exist legislatures, pre-exist the judgments of courts. In the early 20th century, a number of elite law professors got enamored of this idea that there are no rights and duties which obligate by themselves. Everything is about consequences or results. And the results they were particularly interested in were legal judgments. So we can't say what your rights and duties are until a court tells us whether or not you're going to get any particular judgment or any particular remedy. And this was the basis for what later became the doctrine of judicial supremacy, that our rights and duties are what the courts say they are. And this, of course, is now just taken for granted, unfortunately, in most law schools, that rights and duties have no existence apart from legal judgment. And so if we want to know what our rights and duties are, we have to wait around for the court to tell us. And this is why we all wait with bated breath every June for the Supreme Court to hand down its opinions in the most controversial, most highly watched cases, because we want to know what the law is. We want to know what our fundamental rights are. That view is completely at odds with the view of law at the time of the ratification of the 9th and 14th Amendments.
So let me ask here, and then I want to get back to the 9th Amendment. Would it be fair to say, and correct me if I'm wrong, when you talk about legal pragmatism, in essence today, we don't recur to some foundational belief and then from that reason our way to the result or what we should now do. We just try to predict where it might go based on where it's been. Is that sort of, it becomes predictive law? Is that?
That's it. So the chief proponent of this idea of legal pragmatism was a very influential American jurist named Oliver Wendell Holmes Jr. And that's exactly how he described the law. Law is merely a tool that lawyers use to predict consequences. So when a client walks into my office, if I'm a lawyer, I should not, according to Holmes, suppose that my client wants to know what his obligations are or what he should do or what is the right thing to do or what his duties are. No, that's not what he's interested in. What he wants to know is what will be the consequences if he does this action. And so it's all about predicting what the consequences are going to be. That's the view that came to dominate American legal education in the 20th century. And unfortunately is still the dominant view today.
Okay. So let's go back here. You were saying that the whole Constitution presupposes a pre-existing law. The 9th Amendment is recognizing that there are certain rights there. Then it refers to other rights. So talk to us a little bit about that enumeration versus other rights.
Yeah. So all of the rights that are declared by the Bill of Rights are rights that can be found in the common law tradition. Some of them are natural rights, rights that everybody has, regardless where they live. Rights of life and liberty, for example. Those are rights that everyone enjoys simply by virtue of being human, by being a natural person in the language of the common law jurists. And this is very consistent with the understanding of the 14th Amendment as well. The 14th Amendment, in fact, repeats the protection articulated first in the 5th Amendment for life, liberty, and property in the Due Process Clause of the 14th Amendment. And it's for all persons. Persons would have been understood to include natural persons, that is human beings, and then to a lesser extent, certain artificial persons like corporations and trusts and so forth. So there are those rights
those being persons that are created by positive law, by the enactment of a statute or something, right?
That's right. That's right.
Right.
So there are certain natural rights which are enumerated in the Bill of Rights, but that doesn't mean that there are not other natural rights which the people retain. That's what the Ninth Amendment says. So, for example, the natural right of a child to be raised by her own parents. This is a long-standing right in the common law tradition, and it's a natural right. It belongs to every human child by virtue of being a human child. It doesn't depend upon where she lives. Just because we named life and liberty in the Bill of Rights doesn't mean that we're abrogating the right of the child to be raised by her parents. The people retain that right. Then there's this other set of rights which aren't part of the natural law, but are part of the common law. Our ancient traditions, which are so old, so venerated, so fundamental, we can't remember a time when we did things differently. So the right to trial by jury is one of these. The right to bear arms is one of these. The right not to have soldiers quartered in our homes. These aren't necessarily part of the natural law, but they're part of our common law. Someone decided in our legal tradition a long, long time ago, it was a bad idea to give the king the power to take people's homes to put soldiers in them, because bad things happen to their wives and daughters, right? Someone decided a long time ago that it was a bad idea to give the king the power to take away our guns. Or it was a bad idea to let the king appoint the judges who would decide our cases. So we're going to commit these questions to juries of our peers. And there's so much practical wisdom built into these rights that we've kept them for centuries. We've kept them for so long, we don't even remember a time when we did it any differently. So those are natural rights, but they're common law rights. And the Ninth Amendment says we're keeping those too. Just because we listed the right to bear arms and the jury trial right in the Bill of Rights doesn't mean we're giving up our other common law rights. So another example of a common law right is the right of natural parents to be the presumed guardians of their natural children. Not enumerated in the Bill of Rights, but crucial fundamental right that the people are retaining. Another is the presumption of innocence. You notice you don't find the presumption of innocence enumerated in the Bill of Rights. Everyone takes it for granted because it's part of our common law. One of our fundamental rights that the people retain, and they're telling you that they're retaining it in the Ninth Amendment.
Great. That's okay. So, and then your point was nothing in the 14th Amendment abrogated that or rescinded that or changed that.
To the contrary, the 14th Amendment makes specific reference to both natural rights, the rights of life, liberty, and property, and privileges and immunities, which at that time would have been understood to include those common law rights that we have as a result of our fundamental law. And then in addition, we have certain positive rights and privileges as well.
Okay. So one of the things particularly important with respect to abortion, which is why the committee had you come testify, is the understanding of the word life at common law, for example. So give us just a moment of what the common law had said with respect to this question of life. And as you're looking at that, I seem to recall in Roe, the court got into questions of metaphysics and ensoulment and all that stuff, not just the legal understanding of the word life. And so talk to us a little bit about how the common law understood life.
So the provision, of course, is Section 1 of the 14th Amendment, which begins, all persons born or naturalized in the United States, skipping ahead a bit, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Then it says, nor shall any state deprive any person of life, liberty, or property without due process of law. So we have three different legal statuses here in Section 1 of the 14th Amendment. We have persons born or naturalized. So there's a provision which has to do with being born or naturalized in the United States, and that subjects them to jurisdiction of the state. So bracket that and set it to one side. Then we have citizens who are entitled to the privileges and immunities of the state law. That's a second category. But then we have this third category. And the category is, nor shall any state deprive any person. It does not say any citizen. It does not say any person born or naturalized. It applies to any person. So it's the life, liberty, and property protection is a much broader protection than the protections in the Privileges and Immunities Clause. So what does it mean that someone's a person? Well, a common law jurist would read this and say, well, there's two kinds of persons in the common law. There are natural persons, as we mentioned a moment ago. There are also artificial persons. Artificial persons are those legal persons, those fictions created by positive law, corporations, trusts, and so forth. Natural person means human being. Now, it doesn't mean human being for all purposes. A natural person is not a completely univocal concept. There are persons who have different legal statuses for different purposes in the law. There are property owning persons, for example, who are going to have certain obligations to pay property taxes, for example. But they're all still persons. They're all persons. So a person is contiguous with a natural person, which means a human being. Okay. And the human being under the common law, it didn't matter whether you were in utero or born. It included the child in the mother's womb. Yeah. So at common law, there was some question about before the 19th century. That is, some question about when human life begins. Their embryology, their science wasn't as good as it is now. But they all agreed that natural persons includes unborn persons. There was no question about that. The line drawing was a little bit more difficult because, as I say, they didn't have the advantage of embryology, the study of embryology that we have now. And so the line they chose was called quickening. And this was when we have some evidence, because the child is moving in the mother's womb, that the child is alive. That's good enough for us to give the child a legal status and protection for certain purposes. Okay, good. Now, there's another thing you've already alluded to, but I'd like for us to talk about just a moment. That in your testimony last August, you had made this statement. You were actually quoting from Blackstone, and I wrote it down here, that the first and primary end of human law is to maintain and regulate those absolute rights of individuals. And in preparing for the interview, I was reading a little Blackstone for light evening reading, and he said this is interesting too. Statutes, which would be, what our legislative bodies, Congress enacts, are either declaratory of the common law or remedial of some defects therein. Would you comment for a moment there about the purpose of human laws and enacted laws and the types of laws that we have? Yeah. So first on the absolute rights bit, so that's often misunderstood. That doesn't mean that I get to use my rights however I want. In fact, Blackstone, John Adams, Joseph Story, all the other great jurists of our common law tradition would have insisted that all of our rights are bounded by our duties to other people. In fact, many of our rights arise out of duties. So you can think, for example, of the right of the child to be raised by her parent. Why does she have that right? Well, because her parents have natural duties to raise her, to educate her, to feed her and clothe her and so forth. So they didn't have this sort of absolute individual autonomy idea of rights. That's not what that means. All that means is that if a right is absolute, that means that the government can't take it away from you without showing that you forfeited it in some act of wrongdoing. And before they can make that judgment, they have to give you due process of law. There has to be some proceeding where you're entitled to confront your witnesses and contest the evidence in front of you. If they haven't done that, they can't take away your life, liberty, or property. Now, all of this presupposes, again, that at least some of your rights pre-exist legal judgment. You had the right before, and the government can't take it away without a judgment which is rendered according to the requirements of due process. So again, the basic premise here is that many of our rights and duties pre-exist positive law, pre-exist the judgments of courts. On the point about the two kinds of legislation, so the common law jurists would have said, that being the case, there are going to be some rights that we want to secure and protect. And in order to do that, we need to give them greater specificity. We need to know with a little more detail what it means that parents have an obligation to take care of their children. Do they have an obligation to send them to public schools, for example? Or is it enough that they could, say, school them at home? Those sorts of questions are a matter of declaring and giving greater specificity to pre-existing rights and duties. And this was known as a declaratory piece of legislation. So a declaratory statute or declaratory enactment declares what our rights and duties already are, and then gives them greater clarity and specification. That's different from what they called a remedial statute. A remedial statute takes the common law as given ex ante at the beginning, and then changes some part of it to correct some defect in it. And so a classic example from American history is the English had a doctrine called primogeniture, that the oldest son inherits all the land. And we Americans said, we don't like that rule. It seems to us inegalitarian. It seems unjust. Plus, we want land to be more alienable. We want people to be able to sell their land and sell their resources so that we can have more commerce. We're a commercial republic. We're not a landed society or an aristocratic society. So American legislatures got rid of primogeniture so that we would have equal distribution of property. That's a remedial enactment. It takes the doctrine of primogeniture as given, but then changes it to adapt it to our circumstances as Americans.
Now, let me ask, in terms of remedial, if a court were to, for instance, rule that natural parents have no right to raise their children for some reason, under a common law system, the court says, no, I think that's a bad idea. Recently, you and I talked just briefly by email about a South Carolina judge that says, I'm abolishing the common law notion of marriage. It just doesn't exist anymore. Would the legislative body or the parliament be able to pass remedial legislation to say, no, there's still a marital relationship, there's still a parental relationship? Talk about that just a moment.
Well, the English idea is that Parliament is supreme over everything. We Americans didn't like that idea either. In fact, if you read the Declaration of Independence, a lot of what the founders are complaining about is actions that the king took in Parliament, actions that Parliament, enactments of Parliament that we said deprived us of certain of our rights. And so the purpose of declaring certain rights and of the Ninth Amendment making clear that there are other unenumerated rights which are beyond the competence of the government to alter, was to say, we want to be ruled by legislatures rather than kings, because the legislature is where we all come together to deliberate and decide what is to be done. And so we're firm believers in legislation. We're firm believers in democracy. We're firm believers in Republican self-government. But there are some matters that are so fundamental and so important that not even a legislator can change them. And the English and American common law jurists were in agreement on this. And interestingly, they gave two examples in particular. One was the rights of conscience, which we owe to God. And the basic idea there, of course, is that our obligations to God are way beyond the competence of the state. The state just has no competence over our relationship with God. That's a completely different jurisdiction beyond the temporal realm. The other example that Blackstone gives, which the American jurists agree with, is the obligations of natural parents to their natural children. and this goes all the way back to Roman law. This goes all the way back to Aristotle. I mean, this is centuries and centuries and centuries old. This recognition that there's something special in the relationship between children and their parents and their biological children, and that this imposes upon a man and a woman certain natural obligations, which are immutable, insuperable. They can't be abrogated. Can't just get rid of them. Now, there's complications when they forfeit their rights in an act of wrongdoing by abusing their children, for example. But again, in the absence of wrongdoing, the obligation of the parents grounds a right to have custody of their children. And that family unit, mother, father, child, is beyond the competence of the state to alter and redefine.
Okay. So maybe we shouldn't get into this, and you can just say, no, let's just not get into this now. But if a court did, if a court somehow said that the state could take your children from you, well, I won't even get into that. Now that I think about it, that would be, I'm just trying to think where a court would do something that would seem so crazy that the question would be under the Ninth Amendment, what would I do about it? When they said, well, you really don't have a right to raise your children. The state can require all children to enter into child care in state schools beginning at age 2 or something,
Well, we don't have to speculate. Because since the Supreme Court redefined marriage in 2015, some states have actually taken this the next logical step and said, well, if marriage doesn't have anything to do with parentage, and if the government can redefine these relationships however it wants, well, then we no longer have to give legal respect to the right of natural parents to be the presumptive guardians of their children. So there's a case that came out of New York State just last year, where a biological father was deprived of custody of his own biological children without any showing of wrongdoing, and custody of the children was given to his former male lover, without any showing that the biological father had done anything wrong to forfeit his parental rights. So this is the sort of dystopian jurisprudence that our Supreme Court, our Constitution, our Congress, all of our state legislatures, all of our governors and presidents would have condemned as recently as 20 or 30 years ago. This idea that the government can just make the family however it wants, but it's now happening. Direct answer to your question, I think the remedy is to do what the people have always done, which is to get together in their legislative assemblies and say, well, we've got to come up with a solution to this problem. We need a legislative solution. We need to get together and deliberate a way to declare and give specific force to these natural rights, to make sure that parents have the right to discharge their natural obligations to their children.
So, Adam, to kind of close us out here today, for people to understand how this common law looks when you actually see it, I think it would be helpful if we could look at the provisions in Tennessee's Constitution governing marriage. Now, many people are not familiar with them, so let me just read, for instance, the first line, and maybe you can help us understand what the Tennessee Constitution is saying here. Now, some states, for example, just made a flat statement. Marriage in this state shall be one man and one woman, or marriage shall only be between one man and one woman. But Tennessee said this, quote, the historical institution and legal contract solemnizing the relationship of one man and one woman shall be the only legally recognized marital contract in this state. So talk to us about what that's trying to communicate in terms of the things we've been talking about.
Okay, so the reference to marriage as a contract is a common law idea. The common law idea basically was everything starts with the obligations that a husband and wife have toward their children. Again, it's all about the right of the child to be raised by her own parents. And so the common law jurist said the reason why the law takes a particular interest in the relationship between a man and a woman is because this is the kind of relationship which is capable of bringing new human beings into being. And so the purpose for treating a marital contract differently, quite radically differently from any other contract, was because this potential for new life and to secure the natural rights of children. Now, that's not to say that you can't analogize the marriage contract to other contracts. Just by reason of the fact that the common law jurists use the term contract, it brings to mind things like partnership agreements and construction agreements and all sorts of other types of contracts. So there's a way in which it's similar to other human relationships. But I take it that the drafters and ratifiers of the Tennessee Constitution wanted to make clear that at least in one respect, it's quite radically different from all other human relationships. And the reason why it's different is because the law needs to secure and protect and erect certain legal barriers around the rights of children, who of course are the most vulnerable members of our society, and of course the most important in terms of perpetuating any flourishing society, to have some connection to both their mother and their father, from whom they get their legal and their biological identity.
And so the word historical institution is serving the purpose to point us back to that understanding at common law? Would that be a fair statement?
That's right. You can read about it in any of the common law jurists, and they're all going to refer to this in common law terms as a right securing the natural obligations which are immemorial, go back from a time when we can't remember anything to the contrary.
Okay. So as the Tennessee legislature considers specifying what the right to life at common law means in Tennessee, that it includes the child in the mother's womb, and so we're going to deal with the medical health profession by prohibiting abortion once a life is detected. Or if the state of Tennessee said, we're no longer going to treat marriage as something we license or give permission to, but we're going to return to common law and allow men and women to enter into a marriage as it's understood at the common law. Has the Supreme Court specifically ruled that on those issues as to whether or not that's a constitutionally, I don't want to say accepted, but it is not ruled that it's not, let's put it that way. It is not ruled that that's not an okay approach to take on those issues. Does that question make sense?
Yeah, no, the court has not had occasion to visit those questions. The challenge, of course, is going to be making this sort of case that there are rights and duties which pre-exist positive law and judgment to a pragmatic American people. And this is why I think fact findings are so important. We need to, a legislature would have to make very, very concrete fact findings about, for example, what abortion is, and what it does not only to the life of the child, but also to the health of the mother. Very concrete fact findings about how children flourish when they are raised by their own parents, and how the intact biological family is so important to the well-being of children, as well as declare that there are certain obligations which we owe to children and we owe to unborn babies, which precede the founding of the state of Tennessee in the United States, and which we must, in conscience, make provision for.
Okay. If I could too, as the non-attorney in the group, I wanted to hearken with where we are. I wanted to hearken back something you said earlier about the Constitution, and if I could have you kind of just speak to that a little bit. Because recently, for me, of course, working with David, learning a lot about this stuff. To me, it's been enlightening to understand the difference between natural law and positive law, and really understand the true function of the Constitution. And something you said earlier about our rights. I think a lot of people, and probably in myself included, prior to working here at FACT, oftentimes we look to the Constitution for our rights. As what we're taught in school. I mean, we look to our Bill of Rights and all these sorts of things. And But I'll have you elaborate, but what I've come to understand is the Constitution is more about limiting our government than it is ascribing rights to individuals. And, I know one of the things that David and I have talked about recently, especially in this coronavirus during this time, is that our federal government is empowered by the enumerated rights the Constitution gives to it. And it does not have any powers outside of that enumeration of those. But our rights are not so. Can you just sort of speak to that point specifically a little bit?
Yeah, and of course, this was the reason why many of the Federalists who drafted and helped ratify the Constitution objected to the inclusion of the Bill of Rights. This idea that by enumerating rights in the Bill of Rights, this would lead people wrongly to the conclusion that our rights come from the Constitution, when in fact it is, quite the contrary. So the particular rights conferred upon the government of the United States are described as powers in the Constitution. A power is a kind of right. A power is a right to change someone else's rights. And that's a very radical thing. It's an important thing, but it can also be a dangerous thing if placed in the wrong hands. And if you read the Federalist Papers, if you read the Anti-Federalist Papers, if you read the ratification debates, you'll see over and over and over how much concern everybody on both sides of the ratification question had to make sure that we didn't make this government so powerful that it could take away our rights. So there wasn't any controversy about the fact that our rights precede government. That everyone was on board with the idea expressed in the Declaration of Independence that our rights come from nature and nature's God, and that government is instituted after the fact to secure and protect those rights against infringement by other people. The trick, said Madison in the Federalist Papers, is once we've given government the power to protect us from other people, we've got to oblige it to limit itself. We've got to oblige it to prevent, to obligate it so that it doesn't use its powers to take away our rights. And this was the idea behind separation of powers, behind the division of powers between federal government and the states, what's become known as federalism. And so build all these various checks and balances into the system so the government gets so busy fighting against itself that it doesn't come after us. That was the basic idea. But the idea that our rights and duties precede the Constitution wasn't even controversial. Everyone just took it for granted that our rights and duties come from natural law and the common law. And that if there's a right or duty that we have by virtue of natural law or common law that we don't mention in the Bill of Rights, that's neither here nor there. We still have the right.
Yeah,
it's good.
I actually was rereading some stuff and saw where somebody objecting to the Bill of Rights was saying, well, we don't spell out a lot of things in there. And I mean, some of them, of course, were silly, like take a bath or brush your teeth or comb your hair or whatever it was. Yeah, we don't spell all those things out. That would be impossible. Well, Adam, I really, really appreciate you taking the time. And Adam is actually still teaching classes online, which is why today he is so finely attired, is that he's been teaching classes. And brother, I really do pray that you'll have a wonderfully positive influence on your students, even as you have on me. So thank you for joining us today for this episode of God, Law, and Liberty. And Gary, I'll turn it over to you to close us out.
Yeah, it's been great. We appreciate everyone joining us, and of course, appreciate Professor MacLeod being here with us. It was definitely an honor, and I just think it's such a big piece of where we are. I mean, especially there's a lot of conversation out here with the coronavirus about, well, all of a sudden you get sick and you don't have any more constitutional rights. And I mean, I know there's a lot of nuance to all of that, and I get that, but I think it's just really important discussion that we all understand where our rights truly do come from. So thank you for that. And as always, we appreciate your feedback and your questions. So you can always email us at info@factin.org, and we'll see you next time.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram at Fact Tennessee.